Hi, I'm Emily, and I am here with Maya Murphy's attorney, H. Daniel Murphy. Attorney Murphy practices at Maya Murphy's law offices in both New York and Connecticut. My question today for Attorney Murphy is, I was once charged with a crime. Will it matter in my divorce?
So as we have covered in previous questions here, the vast majority of divorces in Connecticut, as well as other states, are settled, not tried. In other words, most cases are resolved somehow around a conference room table or in the hallways of the courthouse rather than in front of a judge with evidence being taken. But that doesn't mean that parties shouldn't be aware of issues which, if the case did go to trial, would become a matter of public record and something that could appear in a decision. Evidence of a crime or even evidence concerning the allegations of a crime, even one which didn't result in a conviction, those are just examples of things that could create some exposure for litigants in a divorce, as well as potentially a tricky area for family law attorneys, especially those with limited or no experience with criminal defense. First of all, the primary question is whether evidence of the potential commission of a crime is relevant to the divorce itself. So the reason for the breakdown of the marriage is both relevant to the issue of alimony and also relevant to the issue of equitable division of property. But the question is whether the alleged crime or someone who is concerned because they have a crime in their past, whether that particular issue is one that contributed to the reason for the breakdown of the marriage itself is something that is going to be a question of interpretation. If the crime alleged is one that relates to domestic violence, for example, that would certainly not be a stretch to say that that issue would be one that's relevant to the reason for the breakdown of the marriage. But if, for example, the crime alleged was, let's say it was a DUI, and there were no children that were involved in that particular arrest or that criminal charge, it then becomes a question of whether or not drinking or alcohol consumption was an issue in the marriage. Perhaps that particular incident, the DUI, had no bearing on the breakdown of the marriage itself, but maybe alcohol consumption or overall insobriety actually did have a reason or did have an impact on the breakdown of the marriage. Or maybe perhaps the DUI as charged occurred during a time in which the defendant lost a job, maybe due to alcohol use on the job or overall insobriety. So in that particular example, it would be relevant to the breakdown of the marriage. And litigants should also understand that the evidence of commission of a crime or even the evidence surrounding the charging of a crime might be relevant for other purposes. And the parties should be aware that discovery in Connecticut especially is very broad. That means that what is discoverable in a case, what is the subject of a deposition or what might be fair game for document production, that is often much, much broader than what is actually allowed into evidence at trial. And so that means that someone can be questioned about something, even if ultimately in front of a judge, that evidence will not be admitted or become part of the formal record. It's also important to your question, how the underlying crime was disposed of. So being charged with a crime is very different, obviously, from being convicted. It's also different from an acquittal. So that is a not guilty verdict after some kind of a finding, or a nollie in Connecticut, which is a prosecutor's declining to prosecute a case, or the entry of another diversionary program that we have available here. In other words, the mere arrest or a ticket or a criminal summons of some kind, it's not enough for that to become an issue in a parallel civil action like a divorce just because it exists. But it does depend how it was resolved. A conviction or a guilty plea or a finding of guilty after trial, that's all fair game. Again, assuming that that particular charge or that particular crime is relevant to the matters that the court would have to decide on in order to divide property, in order to award support or decide custody in a case. A dismissal or an acquittal or a disposition pursuant to some sort of diversionary program that entitles the defendant to basically go back in time to the status he or she occupied prior to the arrest, well, that's a little bit different because the problem there is that he or she may not lie under oath and say that the underlying events did not occur. And I mean lie under oath in the context of a divorce deposition. If they're asked about the underlying conduct of a DUI charge, even if that case was favorably disposed of, they would be best served, obviously, to tell the truth and to tell exactly what happened. That's the same for a diversionary program, such as an alcohol education program, a family violence education program, accelerated rehabilitation, or any of the other diversionary programs that are offered here in the state of Connecticut. The problem lies in that by denying it on the record, or even by admitting it on the record, and being asked about it, now you've taken something that is ordinarily sealed and not of public record, and now you've placed it into the public record. And if you do it in the context of a divorce trial, it may well wind up in a decision in the divorce. There are creative ways to handle this, and for this reason, if you have a criminal record, or even more importantly, if you have circumstances in your case or in your past in which you have been charged with a crime which was later dismissed, you should consult with a family lawyer who has experience in handling and disposing of criminal matters as well.
Attorney Murphy is available 24/7 and can be reached by calling 203-221-3100. You can also email Attorney Murphy at hdmurphy@mayalaw.com, and please visit mayalaw.com for more information.